I'm Jeb Butler of the Butler Law Firm. Today we'll talk about a truck accident settlement that we recently reached on behalf of one of the firm's clients. We'll first talk about the collision itself, and then we'll talk about the litigation, and after that we'll talk about some numbers. We'll talk about the damages and the past medical bills in the case. We'll talk about the mediation that occurred and then the settlement that came afterward. But first, the collision. This was a really serious collision on an interstate here in Atlanta, Georgia. And we'll just start looking at some pictures. Here's an overview of the collision. You can see here that the commercial truck had just demolished our client's car. You'll notice I have removed or redacted the name of the truck company from the side of the truck. That's because one of the terms of the settlement requires us to be confidential about the name of the truck company. But you can see it's a really serious collision here on the interstate. Here's a closer up collision, and you can see here these gouge marks, these white gouge marks in the road behind the truck. What that actually is it's marks left by the undercarriage of our client's car. So the truck smashes into the car back here and hits it so hard that the car skids forward like that, with the tires blown and the undercarriage scraping on the pavement. And that's what causes those marks. You look at these pictures and you would think that nobody could possibly, particularly this one, you look at these pictures and you think nobody could possibly survive this collision. Fortunately, you would be wrong about that. Our client survived, and his injuries, amazingly, were not all that serious. I mean, he was hurt, but it wasn't nearly as bad as you would think from looking at these pictures. This is another picture of his car from the tow lot. And if you look at this picture, you can kind of get a sense of how he survived. I mean, he's the driver, right? So he's up here. And you can see that as bad as the collision damage is, there is some survival space left there in the occupant compartment. So that's the collision itself. We found out from reviewing the police report pretty early on that the truck driver just fell asleep. I mean, he didn't try to hide. He admitted it on the scene of the collision, told the police officer that, yeah, he fell asleep while he was driving. That's how it happened. So we got the case and we filed the case. And we'll talk a bit about the litigation. One of the first things you have to do in a truck case like this is figure out who the defendant is. Because these large companies, and this was a big, actually fairly reputable company, they've got so many different LLCs and partnerships and corporations and other business entities that you have to puzzle through who the right one is. And that can be hard, and a lot of times that is deliberate. A lot of times the company will want to put most of their assets, most of their money in one big company, and then have a bunch of smaller ones that actually operate the trucks. And they hope that if that happens and then they hurt somebody, perhaps the person who's hurt can only get the assets of the little company. So here we filed a lawsuit. We did a lot of homework trying to figure out which the right company was. I've had to redact or remove the names of the companies we sued in the civil action number, but we filed the State Court of Gwinnett County. And this is where our list of all the defendant companies was, and you could tell from the fact that I've had to redact 4.5 lines that we sued a lot of different companies to get to the right one. Notice too, we sued John Doe's 1 to 4. And the reason we often, not in every case, but sometimes we'll sue a John Doe is because if we're missing a company, that allows us to come back in and substitute it for a John Doe defendant later. And in fact, that's one of the things that happened in this litigation. We got into the case and realized there was yet another shell company out there that was involved in this case. It was one of the many related companies, and we had to sue that one. And it's procedurally, it allows us to move the case a little faster if we have a John Doe to substitute. So you'll notice that this is our amended complaint. What that means is that we figured out during the litigation that there was another one we needed to add. We went back and added that company. As you come down here, you'll see we added paragraph 3A, and this explains here what's going on. We originally named John Doe's as other entities or people that were involved, and then We learned that there was another one who actually employed the driver. So we came back and substituted that new entity for John Doe number 5. So we had originally started with 5 John Does. We had to use one to substitute in this entity. And so that's why if you look back at the caption on this page, we now have John Doe's. We have John Doe's, well, I can't highlight it. We have John Doe's 1 to 4 shown there. Another thing we learned in the litigation that was pretty interesting, you know, whenever there's a massive collision like this and the impact speed is just that tremendous, you wonder what actually happened out there. So we got to sniff it around. We know that under the FMCSR, Federal Motor Carrier Safety Regulations, when there's a collision like this, the truck company is supposed to conduct a drug test of their employee, and they didn't give us a drug test. They're supposed to produce that or hand it over in the discovery process. During the litigation, they didn't. And we figured out what happened was the company had asked the driver to do a drug test, and he refused. So they fired him on the spot. So that, of course, let us know a good bit about what was really going on out there on the roadway. We talked about how, you know, given the severity of the collision, our client wasn't hurt that badly. You would think he would have been killed, given the damage to his car, but he survived. And we'll talk now about the damages, which is another way, kind of a legal way to say the injuries or the harm. You know, he had a black eye, he had several fractures, but they all healed without surgery, so his past medical bills were not as high as we sometimes see. I mean, if I were looking at that car and knowing that that's a collision with medical treatment around Atlanta, Georgia, I would expect to have past medical bills well into the hundreds of thousands, maybe into the millions of dollars. But that's not what we saw here. His past medical bills are actually only $67,000. And you know, that's a big number, right? But it is way smaller than you would expect for a case like this. But anyway, we got to litigating the case. The other side, the insurance company figured out we were serious. They asked us to go to mediation. A lot of folks have probably heard about mediation. Briefly, if you haven't, it's where the two sides to the case go to a third party, to a neutral person, and sort of pass numbers back and forth and see if the case can be settled. Sometimes that works and the case settles, and sometimes it does not. On this occasion, we went to the mediation, and we were expecting some pretty serious money to be put on the table, and it was. They offered up to $420,000, that is about 6 times the past medical bills at the mediation. That's a pretty good result. There are a lot of lawyers who say 3 times the past medical bills is what you shoot for. They offered 6 times. We thought we could do better. So we actually walked out of the mediation, said goodbye, that's not enough, and we left. A little while later, you know, the phone rings and they got real serious, and the other side made an offer that our client decided to accept, and the case ended up settling for a total of $700,000.